they're still active here?
There is, all the books are still active.
I joined the one in Portland.
Yeah, that
I've lived
was
there for the
the-
last 10 years, but
Yeah.
I haven't gone since COVID because I
All three of my
don't
girls.
have any reason to.
All three of my
drink
girls
anymore.
got the scholarship from something.
Oh, really?
You're late.
Ready to go already, Shelley? You don't want to wait for Daniel?
That's right.
Yeah.
Give it a go?
Taking your space.
I haven't heard from him. Do you want me to wait?
Let's see, we got 5:31.
So I guess it's time to go. Good evening, everybody. Welcome to the Monday special edition of City of Lewiston's Board of Appeals. Today, April 29th, 2024. Shelley, can you help me with a roll call?
Certainly. Yes. Daniel Dubé.
Not here.
Not here. Paula Maselli.
Here.
Bernard McAllister.
Here.
Melanie Dorn.
Here.
David Prjansky. Paul Colasante.
Here.
And Matthew Agron.
Here. Looks like we've got everybody, including me. I am just first, before we get started, Shelley, who are our two alternate members?
Paul Colasante, Matthew Agron.
All right, so as of right now, we have two, and we're missing one of our regular boards, so one of them needs to vote in this occasion. Do either one? So before we get started, I'm going to have to clarify that, but I'm going to make sure we have no conflicts first. So we have a petition for appeal submitted by 36 Shore Rd LLC for an administrative appeal regarding the property at 36 Shore Road in Lewiston. The applicant is appealing a staff memo regarding the interpretation of a City of Lewiston Code of Ordinances or the application of the code to the property based on the applicant's oral representations of its intent to move and enlarge the existing structure located on the property. Before we get started, does anybody on the board have any knowledge or familiarity with the borrower, which is 36, I'm a borrower, I'm a banker, guys. For the applicant, 36 Shore Rd LLC, and or the Mr. Michael Drynan. And no conflicts? I don't have any conflicts. So we have everybody, so I guess for this evening, I'm gonna look to my left first, and I'm gonna say, Matthew, you'll probably be our voting member this evening. And then we'll just keep going with where we are, okay? So with that, I'm going to open up and I'm going to look to the other Shelley to help us with a summary memo of where we are and what the issue at hand is.
Okay. So this evening, the petitioner is challenging a part of a memo written on December 1st, 2023 by land use planner Craig Tebow. This memo is about development challenges related to 36 Shore Road. It included 4 sections that detailed the primary constraints to development of that property, and they have appealed one of those sections. The board, on February 21st of this year, had a hearing where you heard their second appeal on this matter, which was dated in January. That was an appeal of staff decision not to send it to the board because we didn't feel that you had jurisdiction in this matter. So following that meeting, a meeting on the first appeal, which is what's happening tonight, was scheduled. Staff's recommendation is that the board would dismiss this appeal on a finding that you do not have jurisdiction for 2 reasons. The first of which is that Planner Tebow is not a code enforcement official. And then the second is because the memo that he wrote is not a decision, determination, or interpretation. So, in summary, if you were to find that you had jurisdiction, so if you find differently in both of those cases, we also recommend that you would reject their appeal based on the fact that the code requires burden of proof be met by the applicant, which they have not done. Their application has not shown that the shed that exists on the property is a non-conforming structure, which when you look at the definition of non-conforming, it means that it was legal at the time it was built. There's no proof as to when it was built or that there was a building permit for it, so it's unclear that it was lawful. And then thirdly, this is based on their appeal, that the ordinance as written does not give you the opportunity to make a finding on the grounds of equitable estoppel. So based on that, we would recommend, if you do decide you have jurisdiction, that you would not find in their favor.
Thank you, Shelley. Mr. Tebow, do you have any additional layman's terms comments as to the intent of your interactions with the applicant? Watson?
Not this time, no.
Not this time? Thank you very much. So with that, I would like to ask the applicant if you're ready to provide any comments related to your application.
Sure, should we come up here and sit down?
Please do, please do,
Okay.
please do.
Michael, I'll ask you to come up here and sit with me, please. Good afternoon. My name is Chris Bond, and I represent 36 Shore Road LLC. With me this afternoon is Michael Drynan, who is the manager of 36 Shore Road LLC. First of all, Mr. Drynan and I would like to thank you all for your service to the city of Lewiston.
That's usually mine that's doing that, so.
Shut her off.
You may want to bring those microphones to you so they can be right on the record. Thank you.
We'd like to thank you for your service to the city of Lewiston. We're sure that you all live busy lives and that there are other important and valuable things for you to be doing right now with your time other than hearing the appeal of a small company. Thank you very much. But while we appreciate your service to the city, I have to state for the record that my client renews its objection to holding the hearing today, a date that has no basis in the code and the 2024 Lewiston BOA policies and procedures. Based upon an unfounded belief that my client was actually engaged in settlement discussions, my client accepted the department's illegal offer to continue the hearing to the month of April. In doing so, the department has apparently concluded that my client also consented to the lifting of all applicable rules under the code and the 2024 Lewiston policies and procedures. I assure you that that was not my client's intention or understanding. In a nutshell, it appears to be the department's position that the sole relevant term of the agreement to continue was that the hearing take place in April, and that so long as the department scheduled the hearing sometime during the month of April, it did not matter what year it was, what day it was, or what hour it was, so long as it was in the month of April. The department is well with the, if that was the case, then the department would be well within the four corners of the agreement. With respect, that is a strained and unfounded interpretation of my client's consent to continue and one that violated the city's own code and BOA policies. Specifically, the chairman shall call meetings of the board as required, 30A MRS 2691, not as the department sees fit to do. All hearings shall be held within 30 days of the receipt of a complete petition for appeal. Lewiston Zoning and Land Use Code, Article 9, Section 2B1. All hearings shall be held within 30 days of the receipt of a complete application, a complete petition for appeal, unless otherwise agreed between the petitioner and the Board of Appeals at the hearing of which public notice has been given pursuant to subsection C of this section, Article 9, Appeals and Variances, Section 2. Accordingly, the department had no authority to continue this hearing to a date that the BOA did not agree to in a meeting for which public notice had been given. Further, the department passed completely over two mandatory dates under the code. Regular meetings of the Board of Appeals shall be held on the first and third Wednesdays of each month, beginning at 5:30 p.m. in the city building. Even assuming that the agreement to continue is valid without explicit detail to the contrary, April means the month of April in the year of 2024 on the first or third Wednesday, whichever is closest to the 30-day deadline at 5:30 p.m. In case I have not made my point, that day, time, and year was April the 3rd, 2024 at 5:30. We're almost a month past that date now. And this is for an appeal that was filed in December. Accordingly, 36 Shore Road claims error on the part of the department and the Board of Appeals. My client preserves all claims and defenses with respect to the city's refusal to follow its own laws. Now I'd like to comment on the procedural issues. The question before the board today is purely legal, for which my client does not bear the burden of proof. It is a question of law. It is to be treated de novo. There are no questions of fact, only law. However, in the interest of full disclosure and context, I'll review the facts leading up to this question of law so that you have a greater understanding of the legal question that you're now being asked to answer. But before I do, I'd like to review some of the procedural history of the case. As mentioned, under the city's code, all appeals shall be heard within 30 days. My client timely filed this appeal on December 28th of last year, over 4 months ago. When my client timely appealed that determination on December 28th, Mr. Tebow responded on January 11th that my client's appeal was void for lack of jurisdiction on the basis that Mr. Tebow was not acting as a code enforcement official when he issued that determination. I expect to cross Mr. Tebow, and I think that the evidence will show that he was working under the direct supervision and authority of David Hediger, who was head of the department. Asserting that Mr. Tebow's argument concerning lack of jurisdiction on the part of the Board of Appeals was an unlawful attempt to avoid review by the BOA, 36 Shore Road LLC appealed that assertion on January 19th. That appeal is now a matter of public record and is posted on the city's website and is our argument against the department's assertion that you do not have jurisdiction in this case.
Please repeat.
Sorry?
Please repeat that again, please, for me.
The appeal that we filed in January is directly on point with our argument that this board does have jurisdiction to hear this appeal. And when the city waived or stipulated that we did in fact have an appeal that could be brought, I thought that was completely resolved. Now we find out that the department continues to assert that you do not have jurisdiction because Mr. Tebow is not a code enforcement official. Where he was working under the direct supervision and oversight of David Hediger, the head of the department, it is hard to imagine that he was not a code enforcement official. And we submitted a long brief in that appeal making that argument. The department relented and agreed to hear the appeal on the basis that it was appealable, and now they're asserting again that you do not have jurisdiction. After they waived, I believe that they waived that argument. Before the January 19th appeal was heard, the department reversed that position and stipulated that upon review of state statute and the city's city's Appendix A zoning and land use code, a public hearing should have been scheduled on December 28th, 2023, after judging it to be complete. Accordingly, at a regularly scheduled meeting on February 21, this body, this BOA, deemed the petition to have been received on February 21st and directed staff to schedule a public hearing on December 28th, on the December 28th petition by no later than March 20th. That order by this board was ignored without any legal authority. At this time, the staff has not held a public hearing on this appeal by no later than March 20th. It is true that 36 Shore Road agreed to continue such hearing until April on the basis the department was engaged in good faith negotiations to settle. This pretext for the agreement to continue was presented in bad faith, as the department has not participated in any settlement discussions and never intended to do so. Accordingly, 36 Shore Road demanded that the December 28th petition be heard by no later than the regularly scheduled meeting of the Board of Appeals on April 3rd, 2024. Staff refused. Accordingly, the City of Lewiston and the BOA is in violation of 30 MRS 2691, Lewiston Zoning and Land Use Code, Article 9, Section 2C, and Lewiston Zoning and Land Use Code, Article 9, Section 2B1. Now, to the substance of this appeal. First of all, do you have any questions about that?
Yes.
Thank you.
So I understand our February 21st date. I was here, chaired the meeting. We approved that it was eligible to come to the Board of Appeals.
Yes.
And we set a date. From that point, I'm looking to staff a little bit, because we scheduled this meeting where we could have a quorum of folks. There was some negotiation of trying to get to the right date. Was there any particular reason why this evening was chosen? Other than I know that I'm looking to staff, because I know our board was not made privy. We were trying to figure out whether we were going to have attendance. That was the only reason we knew it, so.
If I could,
Yes,
Mr.
Vice
Chairman. My name is Michael Carey. I'm the
Thank you.
city attorney. In this matter, I'm representing staff and not the Board of Appeals.
Right.
The Attorney Bond set forth a number of procedural objections, kind of the order that he raised them, that I have them, that the hearing being held today is improper, that the burden is strictly a legal question, talked about the code enforcement official argument, and that and then kind of went into detail on coming back to the hearing issue and why that was presented in bad faith. And so I'm going to address them, if I may, in order of, kind of in sequential order. This is going to be in the nature of responding to the objection, and there's quite a bit of, it's said to be strictly legal, there's quite a bit of fact and kind of argument in there that I don't understand kind of what the basis is before this body at this time. But let me kind of hit the high point. In terms of when the hearing, so there was the argument, so I'm going to start at your first hearing in this matter. I can't speak to what Mr. Bond understood. What the staff proposed was a stipulation that staff were in error to not schedule the meeting for this board to determine jurisdiction. There was no suggestion that the code enforcement official argument was waived. And in fact, in a later conversation, I reinforced that with Attorney Bond. So that is in terms of the facts of that, I turn you to your board packet, and I think you'll find there that what was specified was that staff should have scheduled for hearing, not that the argument was waived. The argument is in fact now to the point that was suggested that the petitioner's argument in the January 19th, I think it was, appeal is sufficient to address that now. There's a long discussion of that. It turns a lot on the dictionary definition of certain words. The key issue here is the assertion incorrectly that ordinance does not define the term code enforcement official. In fact, it does. That definition is provided in the memo from the Planner Norton, and that is in your packet there. And so the entire argument is based on a false premise, which is the discussion of an undefined term. That term is defined. Moving forward in time, I believe you'll remember that order required the scheduling of the hearing within 30 days. And I have a communication, if the board is interested in taking it into, I'm going to find it here, hold on a second. So and I'm going to read into the record, and again, I'm happy to provide the email if that's important for the board. Deputy Director Norton wrote, "Would you be interested in a mutually agreeable extension to the Board of Appeals to an April hearing? I haven't heard your response to the forward below, and I know you and the city attorney are communications that aren't resolved yet, so I thought more time to work things out would be beneficial to both parties." And so the key word there is to an April meeting. Attorney Bond's response, "Good afternoon, Shelley. I have consulted with my client, who consents to moving the pending appeal to April, and hope that the additional time to allow parties to craft a suitable settlement agreement concerning all outstanding matters."
Thank you.
The Attorney Bond has raised the existence of settlement negotiations. That is typically something that is outside of the purview of a decisional body. And other than acknowledging that those existed, the city at this point is not going to go beyond that. To then go and to characterize the fact that they were not resolved to one party's satisfaction as evidence of good faith is absolutely without background justification, but again, anything that is before this board now. Then the question becomes the scheduling of the hearing date. There's a long exchange, 20 pages, I believe, when I printed it today, that started with an email on March, I don't see that, March 18th, on a number of issues, one of which was the scheduling of the hearing. In pertinent point, it writes, at this point, 413 is out, packets are due in just over a week. And later in the discussion, we went back and forth on a number of legal points. I think the critical point is that there were, I believe, 11 days suggested, asking for the consent of when the applicant could meet. I never got a response to that. The earliest date to that was April. I'm thinking 4, and I'm saying March. April 8th, 5 days after. And so and I asked a number of times in this for pertinent authority. The last one was March 22nd, that after he provided authority, I responded with responding to that authority. Michael, I don't understand why you're spending so much time on this. And 6 days later, he then came with the ordinance citation he's arguing now, at which point we were within 7 days of the April 3rd date. So that is there's absolutely no detriment to the petition. This is something that's entirely in consequence with good faith negotiations, trying to find a solution that would work for a hearing date so they could be here. Finally, I'll leave the question about burden until later, other than to observe that it's not strictly a legal question, that when the different facts are required, it is not a question, strictly a legal question. Many of the facts that are suggested are heavily contested, and it, again, doesn't go back to the actual ordinance that you must apply, which doesn't speak to burden of proof specifying it is different from fact or law. And then finally, the whether or not this hearing is de novo, which Attorney Bond suggested, or appellate, again turns on ordinance. It is presumed to be de novo, which means that you can take evidence unless the ordinance says you're strictly acting in an appellate capacity. Lewiston's ordinance does not, so this hearing is de novo. That does not mean that it is a legal question or a fact question. If it's a legal question, no facts are required. This is a de novo hearing and you may take. So I apologize, wanted to be succinct and happy to speak further or have staff speak to some of the facts behind the questions if you have them.
Thank you, Attorney Carey. None of which are the issues that I had any idea we were coming into having a conversation about. This.
Understood.
Other questions from our board right now for either the applicant or Attorney Carey or the city at the present time? So we have first issue, the issue was brought up, but I'm going to ask you, would you like to continue in providing additional commentary?
Yeah, so
Either-
I just like,
Sure.
Attorney Carey, I think has conceded that the department did not have the right under the code to depart from the order that this board gave at our last hearing, which was to hold the appeal at March 20th. Department, I fully admit that we conceded, we consented to that with an understanding that we feel was not valid. Nevertheless, the whole point is nobody had the authority to depart from the order that this board gave, that you gave. You ordered it to happen on March 20th. It did not happen. And there's an old saw in law, justice delayed is justice denied. And our appeal went up in December. We've been delayed a lot. Moving on, so there's two questions, I believe, before the board. First of all, the question before the board is whether the Department of Enforcement and Planning has the legal authority to presume that all existing non-conforming structures within the shoreland zone are unlawful absent a permit applicant's proof that the non-conforming structure was in lawful existence at the time that the shoreland zoning ordinance was enacted. The second legal question is whether even if such legal authority exists, may the department require that such burden of proof, regarding lawfulness may only be met by the production of evidence that has never been required of any other non-conforming structure within the department's files. for any other non-conforming structure within the shoreland zone of no-name pond. I'm now going to call Michael Drynan to offer his testimony concerning the factual and procedural context of these questions. Oh, by the way, the answer to both these questions is no. There is no authority for the department's position that existing non-conforming structures are presumed unlawful. Further, there's no evidence that the department has ever attempted to apply such a rule. Mr. Drynan, would you please raise your right hand? Do you promise to tell the truth, the whole truth, and nothing but the truth, sir?
I do.
Please tell them, for the record, tell the board what your name is.
Michael Drynan.
And what's your interest in 36 Shore Road?
I am the manager of 36 Shore Rd LLC.
And please tell the board how you first became aware or interested in the property at 36 Shore Road.
It was publicly listed on the MLS.
And what is your personal interest in it?
I noticed it was a relatively inexpensively priced waterfront property, and I like to fish and kayak and canoe and camp and recreate in those ways.
Please tell the board why 36 Shore Road LLC was organized.
It was organized for the sole purpose of purchasing 36 Shore Road in Lewiston.
And can you describe the property? Is it conforming?
No, it is a non-conforming property. What drew me to it was, again, the waterfront location, but most important to me was the presence of an existing structure on the property.
Please tell the board how you first became aware of the property. Well, you've already said it was publicly listed. Please tell the board what you learned about 36 Shore Road.
I learned that it was again, a waterfront property of a certain size with an existing structure, 4 walls and a roof, relatively old, I would say some decades by its appearance.
And did you do a site visit?
I did, on or about May 20th, 2023.
And did you investigate the structure with the seller's broker?
I did not visit that day with the broker. The broker had had other visits, and my attorney, Chris Bond, had been in contact with the the listing broker.
And do you know what the structure was used for generally?
The prior owner used it for their own purposes, storing fishing, camping equipment, etc.
And do you know when did the sellers indicate that they built it?
They bought the property, I believe it was June 24th, 1988, and they told us they had built it shortly thereafter. So I had assumed it was in place, if not in 1988, then no later than 1989.
Does June 24th, 1988 refresh your memory? Is that as a date that it was purchased by the previous owners?
Yes, that's the date they purchased the property. And they said they built the structure shortly after purchasing the property.
And has the city been able to tell you when the shoreland zoning ordinance was enacted in Lewiston?
No.
Did you do a FOIA request to find out?
Yes.
And was any authority provided to you as to when the shoreland zone was enacted?
No.
And have you tried to find out when the shoreland zone was enacted other ways?
I have.
And what did you do?
I contacted the Maine State Library, and I started looking at old editions of the Lewiston Sun-Journal. And during that search, I discovered it appears it was adopted by the city of Lewiston in January of 1992.
And that's after when the seller said that they built the building?
Correct.
Based on that information, have you formed any conclusions about whether the existing structure at 36 Shore Road is a lawfully non-conforming structure?
Objection. This is a question of fact. That's a legal conclusion for the board.
I like we're having a lot of fun with these, but we're not in a court of law here either. I'm not a judge unless I got promoted so recently. So I just want to be clear. All right, I'm listening to this as normal Board of Appeals, so we're going through a lot of legal precedent, procedure. This is a board, I'm gonna handle it that way. You mentioned cross-examination earlier. We don't do that at the Board of Appeals.
Well, unfortunately, Mr. Chairman, the statute, the main statutes allow it.
I'm gonna there's gonna be comments and questions as we go along, but I'm just being clear.
Yeah.
Don't take me down that road.
Mr. Chair, if I may, I
Please.
apologize. I understand that you're going to run the hearing as you will. I may interrupt and make objections as I did.
I understand that,
For the
you know,
record.
I mean, we have legal representation on all sides here. Do what you need. I'm just being weird. None of us here are judges. So please go on, Mr.
I'll
Barr.
renew the question. Based upon the research that you did, going to the Lewiston Sun Journal archives and the other gathering information you did from the sellers, did you form any conclusions about whether the structure is lawfully non-conforming?
I did. I believe it was a legal non-conforming structure that existed before the adoption of the shoreland zoning ordinance.
Thank you. Now let's return to your investigation of 36 Shore Road prior to acquiring it. When you became aware of the structure, did you form any conclusions about its age?
I did. I know something about buildings. I'm a landlord and property owner, and I have a fair amount of building experience. And the building looked some decades old, if for no other reason than the asphalt shingled roof, which was protected in large degree from the weather by the canopy of trees, was completely deteriorated. And they were your typical 3-tab, most often 30-year shingles, and there was virtually nothing left to them. So I would say that alone would lead me to believe that it was at least 30 years old.
So what did you do next after you did the site visit?
I contacted the City of Lewiston Code Enforcement Department and made a plan to visit with them to see what, if anything, could be done with the property.
And what did you learn?
Not a whole lot. They were not aware of the existence of the structure, and so the discussions at that point were rather vague and non-committal.
So you had a meeting with code enforcement before you bought the property?
Correct. There was a period of due diligence in the purchase and sale agreement, and that is exactly the reason from my end for having that period of time to investigate things just like this. What, if anything, can I do with this property?
And did you have a particular code section that you were concerned about?
Yes, and the shoreland zone standards, subsection 8C1D, talks about expanding an existing structure in the shoreland zone.
And did you speak with Mr. Tebow about that?
I did.
And
I cannot say I referenced that specific section at that time, but I definitely had a discussion about, yes, what can we do with this property given its location, et cetera.
oh, I'm sorry, let me back up. One question I want to ask you, Mr. Drine, is did the seller say that you could expand the structure as you wanted to?
No.
In fact, they had some information from the department saying that you could or could not expand the structure.
They were told they could not, and it was listed in the MLS that it was not a buildable lot.
And then, did you share that with the sellers?
Yes, because their broker had emailed code and was told that, and he shared that email with us, and we had a general conversation about that very issue.
So the sellers were sharing information with you, and you were sharing information with the sellers?
Through their broker, correct.
And based on all of that analysis, you developed a conclusion that subsection 8C1D would allow you to expand the structure and move it and expand it.
Correct.
Now, did you just keep that to yourself, or did you want to talk to the city about that?
No, I believe I shared that news with the city.
And why would you want to share that with the city?
I had to make a determination whether to proceed with the purchase of the property.
And the city had come out and said you can't do anything. That's what they're telling the sellers, right?
That is correct.
And when you met with the city, what did you learn? Did you learn that they were completely unaware of the structure?
Yes, they were unaware that there was a structure on the
And that was
property.
Mr. Tebow that you met with?
That is correct.
And Mr. Tebow and Mr. Hediger had both been involved with that email, is that correct? The email to the sellers saying that they could not do anything with the property?
I believe both were on it. I can't.
And yet, your conclusion from talking to Mr. Tebow was that before they issued that opinion to the sellers, they did not even go visit the property.
That is correct. To the best of my knowledge, the first visit by code was the day after we met with them, the first visit to the property.
And do you remember when you met with Mr. Tebow?
It was May 22, 2023.
And what happened at that meeting?
We had a general conversation about the property. He was non-committal, as I said. He couldn't say that we could do what we hoped to do, but he also did not say we could not do what we hoped to do. Again, he said he had to visit the site, and he could make no further determination at that time.
And did Mr. Tebow understand what you were looking for?
I believe so. I think I was fairly explicit.
And do you know if Mr. Tebow did a site visit of the property and whether he confirmed the existence of the structure?
He did. I believe it was the next day, and we, at some point here, saw the pictures he took that day.
So what happened after that site visit? Did you have any communication with Mr. Tebow?
You know, to be honest, I'm not sure. I don't think there was much communication after that, and we proceeded to close on the property.
At that point in time, had you acquired the property?
No,
But you had learned that the city had told the sellers that the property could not be developed.
correct,
And they clearly offered that advice without performing a site visit.
correct,
And the terms of the sale were largely influenced by the city's advice, is that correct?
correct.
So did you get a feeling that the city was just, by not going along with your idea, they're just refusing to do an about-face and what they'd already told the preventers?
I really cannot ascribe any particular motivation for the city's actions, but it did seem to me that, yes, they had committed to the seller that the property was not buildable, and I had developed a very strong feeling that, in fact, it was.
Did Mr. Tebow ever inform you that there was no building permit on file for the existing structure?
Not at that time, I believe at a much later date, but no mention was made at that
So he
time.
did not raise that as a possible
No.
hurdle for you to get over?
No,
Did Mr. Tebow inform you that you would have to produce original building permit before you'd be able to move forward under subsection 8C1D?
I have not at that time in May or June of 2023.
Would that have been highly relevant to you if you'd said that?
It would have been,
Because according to Mr. Tebow, there is no original building permit, is that correct?
that is correct.
So he would have essentially been asking you to produce something that he knew did not exist, is that correct?
Yeah, that is correct.
Did Mr. Tebow inform you that the city had no property records of the existing structure on file?
I don't believe so, no.
Did he inform you that the issue of whether or not there were property records was an important concern in this matter?
I don't believe so, no.
At that time, was Mr. Tebow aware of the fact that your only interest in the property was contractual?
Yes, we were, had not yet purchased the property.
At this point, the land and building were still owned by the seller.
Correct.
But did you make it clear to Mr. Tebow that if you did acquire the property, it was 36 Shore Rd LLC's intention to move the existing structure and to expand it under subsection 8C1D of the Shoreland Area Standards?
Correct.
And at any time during your meeting or following your meeting, did Mr. Tebow state that based upon his inspection of the property or his knowledge of the code, that you could not do what you were interested in, what you intended to do with the property?
Not at that time, no.
To your knowledge, did Mr. Tebow or any other code enforcement official or officer charge the existing owner with the failure to make application or to obtain the required permit for the existing structure?
Not to my knowledge then or now.
To your knowledge, did Mr. Tebow or any other code enforcement official or officer charge the existing owner with a notice of violation for the unlawful construction of the existing structure in violation of the city's building code or shoreline ordinance?
No,
To your knowledge, did Mr. Tebow or any other code enforcement official or officer charge the existing owner with liability for any citations or civil penalties for the construction of the existing structure?
no,
To your knowledge, did Mr. Tebow or any other code enforcement official or officer serve the existing owner with a summons or land use complaint pursuant to Rule 80K of the main rules of civil procedure?
No.
And Title 30A MRS, Section 4452?
no,
Hearing no objection to the lawfulness of the existing structure or seeing no action taken with respect to the lawfulness of the structure, did you waive your conditions and move ahead with the acquisition?
I did.
And then what happened next? Did you ask me to reach out to the city?
Well, I believe nothing happened until November of 2023.
Yes?
I mean, there was no mad rush on my part to engage in any particular plan of action after having just purchased it in the middle of July. So yes, I did in November ask you to reach back out to the city about further discussions regarding expanding and moving the existing structure.
And did you receive a response from the city?
I believe we received a letter, I think it was December 28th of 2023,
Would December 1, 2023 refresh your memory?
maybe December 1, a long letter detailing many reasons why the property could not be developed in any way.
And was that letter copied to the director, Mr. Hediger?
I believe it was.
And during your FOIA request, did you get any emails indicating that Mr. Tebow and Mr. Hediger worked together on that letter?
Yes.
Would you read the top of that email, please, into the record?
From Craig Tebow to Shelley Norton, David and I worked on the attached determination, and that was sent out December 1, I believe. We then met with Chris Bond and the owner at the end of December when they submitted the first BOA application. David and I then spoke with Mike, who had the opinion that as I am not a code enforcement official, technically my letter cannot be appealed unless it is adopted by Nick, Steve, or another CEO. I then sent the following email to Chris Bond on January 11. I think that's the meat and potatoes of it all. There were also the pictures I took from the property visit attached.
And the next email below that is the short one. Would you just read that?
From David Hediger to Craig Tebow on December 1.
The same date as the...
Yeah, shortly after the time of that. Oi, this is a challenge. Good job documenting the path. Be sure to enter into EnerGov, possible with a land use hold, comma, 2.
So it appears that the determination was sent out with the full knowledge and consent and authority of the director of the department.
Correct.
Did that determination present any surprises, Mr. Dryan?
Yes, many. The most important from my perspective being the requirement of an existing building permit for the structure.
In other words, that you had to prove that the structure was a lawfully non-conforming structure.
Correct, by finding and delivering, if they didn't have it, a building permit.
And did Mr. Tebow provide any authority for his position that you would have the burden of proving lawfulness using a building permit?
Not that I'm aware of, no.
And did the department cite any evidence at all of its own that the structure was not lawfully non-conforming?
No.
Did the city provide any basis for concluding the structure was not lawfully non-conforming?
No.
Since you filed this appeal, have you had the opportunity to determine if the absence of a building permit is unusual among structures built around the shoreline zone of No Name Pond?
I have.
What did your review of the property files of structures within the shoreline zone tell you about the department's enforcement of building permits prior to the enactment of the shoreline zone?
I looked at about 30 files of properties abutting No Name Pond, and in not a single one did I find a building permit for any of the original structures, even though many files, I submitted 2 examples with tonight's package, were filled with all kinds of building permits issued for a variety of things, electrical upgrades, septic systems, deck modifications, whatever, all kinds of building permits issued. And in no file was there either A, a building permit for any original structure, or B, any mention of any such requirement to proceed in getting a building permit.
So the department essentially charged you with proving something that nobody else had to prove before getting a building permit. You found no evidence in any file that you looked at, up to 30 files, where the city required a non-conforming structure to prove lawfulness
That is correct.
before they got a subsequent building permit.
That is correct.
And in none of the files that you looked at, did you find an original building permit for the original structure?
That is correct.
So this was a fool's errand. They were telling you to prove that you were lawfully non-conforming, you had to prove a document that your structure did not have and no structure that you examined had.
That is correct.
How many, oh, you already answered that. In any of those files, did you find any evidence that any of the original structures were actually granted permits and built before the enactment of the city's shoreline zoning ordinance? Any evidence that any of the original structures were actually granted permits and built before the enactment of the city's shoreline zoning ordinance?
I'm not sure I understand that question. Many of them had, actually, not many. Most of the files, the building permits didn't start till the 90s. But whatever, there were cases of building permits in the 80s or maybe a few earlier, before the enactment of the shoreline zoning ordinance.
Were they original, for the original
No,
structure?
no, these were all subsequent modifications. And the same with building permits issued after 1992. Many of those in the 90s and aughts, et cetera.
And I believe that you provided to the board an example of 2.
Two
Can you
property
describe
locations.
what you submitted?
182 Bradbury Road, an 8-page file, different things going on. 204 Bradbury Road, a 21-page file. The earliest document on file for 182 Bradbury is 2006. For 204 Bradbury, it's 2007. And these for repairs and improvements for non-existing structures. Bradbury Road is a particularly confusing setup because at some point they changed the addresses around, so if you were to look at the files, it does get confusing. But again, these were just 2 examples of the 30-plus files I looked at.
None of them had original building permits for the original structure.
That is correct.
And was there any evidence that any of the owners of those structures had to prove or go through some process to prove that they were lawfully non-conforming before they could get a subsequent building permit to modify their structures?
No, no such reference in any file that I examined.
So the 2 hurdles that were set out for you to accomplish in the December 1 determination letter from Mr. Tebow, you found no evidence that either of those requirements were being imposed by anybody else in the shoreline zone.
Of the files I examined, yes.
Is there, in the December 1 determination, there's a rebuttable presumption set up. Can you describe what that rebuttable presumption is?
Objection, leading the witness.
Even though he led me, I'm not Well, I mean, if you're talking about the need for a building permit, I would say, I'm not sure that's what you're alluding to.
Well, was the determination letter essentially saying that unless you can prove, using a building permit, that you're lawful, you will be deemed to be unlawful?
Oh, that is correct, correct.
And when you examine the records of these 30 different properties, could you see that essentially the rebuttable presumption was opposite that?
Yes, it seemed to be, by default, that they were all legal, non-conforming structures, since there was nothing in any file to the contrary.
And why do you think that is?
I really have no idea. They just weren't required back then. I can,
The one thing, has it been a consideration of yours that the city was caught asleep at the switch when it issued the determination, or the letter to the preventures?
oh, okay, I thought you were asking me why there were no permits in the files originally. Yeah, again, I cannot ascribe motivations to anyone. I do think perhaps that maybe perhaps the city was caught with its guard down by telling the seller it was not a buildable lot, and maybe subsequently determined that under some cases it could be, and they wanted to perhaps stick to their guns and just say that, no, it's not a buildable lot. I don't know.
Board members, with respect to the department, it is our assertion that the determination letter issued December 1, 2023 was a naked attempt to deny 36 Shore Rd LLC its lawful property rights in order to hide clear error and negligence with respect to the guidance the department issued on at least 3 separate occasions to the sellers, to the prospective buyers, and to the new owners, all for the purpose of protecting its own interest and reputation, not to serve the occupants of the city of Lewiston. Based upon all the research and documents reviewed leading up to this appeal, it appears that the department is arbitrarily, knowingly, and willingly fabricating and applying rules for the specific purpose of denying 36 Shore Road equal protection under the law. Equal protection under the law. The department seems clear on the record that it allowed other people time and time again, every time, the opportunity to modify, to get building permits without any showing of proof. We come along and all of a sudden we have to show proof. If any of you have any questions, I'd be happy to answer them.
Thank you, Mr. Bond. Does anybody on the board have any questions for Mr. Bond or Mr. Dryden?
Mr. Chair, can I just say one thing? I want to apologize to the city of Lewiston for my poor choice of words and an analogy I used with the department's motivation given the events of this past year. So it was a spur-of-the-moment thing. I would not use that analogy again.
Okay, thank you. Does anybody on the board have any questions for the applicant or his attorney?
This time.
And I still want to call Mr. Tebow.
I understand. Mike, I'm sorry, Attorney Carey,
Thank you, Mr. Chair. I do have a couple questions for Mr. Driner, if I may.
please do.
So you've acknowledged that the sellers thought the lot was not developable, and they had an email opinion to that effect from the city.
Correct.
And that the city learned about the structure when you told the city planner about it.
Correct.
And in that conversation, he was non-committal about whether the existence of the structure meant that it could be moved and expanded.
Correct.
And he went to the site after that day. You think it was a day or two after that conversation?
I believe it was the next day, correct.
You testified you didn't follow up after his site visit?
He didn't or I didn't?
You didn't.
I'm not sure I knew that he went until later. I knew he was going to. I'm not sure I knew that he had
Right.
gone.
But you didn't follow up one way or the other before you purchased the property?
I don't believe so, no.
Okay. You don't know whether he was still committal after doing any investigation he might do.
I'm sorry, could you,
You don't know whether he was still non-committal about your theory about moving the structure and expanding it.
correct.
And you didn't ask for a written opinion before you purchased the property.
Well, I had already seen a written opinion to the seller, but, so I did not ask for a subsequent one. I had formed my own opinion by then.
Understood. And you didn't communicate that opinion in writing, either as an opinion or as an email even to staff.
I'm not sure, I don't believe so.
And so, if I understand correctly, your testimony is the last written record is the city's opinion to the seller's broker about whether or not the lot is developable until sometime in the fall.
I would say that's correct.
Did you go in and look yourself for whether or not there was a permit?
I probably would have looked at the file, but the fact that it lacked a permit did not particularly have any relevance to me, given the location and what I perceived to be the age of the structure.
And you're aware that building permits were required to build structures in 1988 and even before that?
I'm not as clear that they were required for a structure such as this.
You read the section of ordinance that the city included in its memo?
I'm not clear what memo you're referring to.
For this hearing, sir. And the city sent out a memo on Friday and posted it to the website with its arguments for this hearing here. And it included a copy of an ordinance from somewhere between 1982 and 1988. Are you familiar with that memo?
I am not.
Okay.
But in any case, the lack of a permit for such a location and such a structure, I did not find surprising.
And are you aware that if the board finds tonight that there's no jurisdiction, you can go up to the planning department tomorrow and learn what you need to do to develop the property and you'd like to?
I am not particularly aware of that, no.
I have no more questions, Mr. Chairman.
Thank you, Mr. Carey.
Mr. Dryden, after Mr. Tebow went out and did a site visit, did you not ask your attorney to follow up with Mr. Tebow?
I did. I'm not sure of the date of that request.
I just don't recall.
Correct.
Okay, thank you.
Okay. With no other questions of the applicant or his attorney, I'm going to ask if there's anybody here in the public who would like to speak in support of the application. I'd like to ask if there's anybody here that would like to speak, in the audience, who would like to speak in opposition of the applicant. That being said, the public portion of this hearing has been closed. The board can have some questions to staff. I understand that you will have an opportunity to ask a question as well. My first question is to Ms. Norton. I want to ask if Mr. Tebow is a code enforcement officer.
No, he's not. His title is land use planner. He also does not possess any of the state certifications for code enforcement officers that would be, you know, he could have them and still have the land use planner title, but he's not currently licensed, or wasn't at that time and isn't now.
Mr. Tebow, are you a licensed or code enforcement officer for the city of Lewiston, or were you at this time in December?
Yeah.
Thank you. Attorney Carey, is it your opinion that Mr. Tebow is or is not a code enforcement officer for the city of Lewiston?
Under the definition in code of code enforcement official, he is not a code enforcement. I agree, it is my opinion that he's not a code enforcement officer as defined by statute.
Thank you.
And under the definition of code enforcement official, he's also not a code enforcement official because that is narrowed to the director and code enforcement officers.
And my next question is regarding your memo of December 1st, Mr. Tebow. I do understand you'd use the term determination in there. But can you please explain the term, was this intended to be a firm decision based on an application provided by the applicant?
There was no application provided. This was meant as an advisory role. And to add to, or sort of predict any questions, I added that termination letter, I added that, that language about it being an appealable, act by the city, because that was what I had interpreted it to be at the time.
Thank you. Before I give you the opportunity to have that, does anybody else have any additional questions for Ms. Norton, Attorney Carey, or Mr. Tebow from the board? Mr. Bond, you have the opportunity to ask a question, through to Mr. Tebow.
Mr. Tebow, so when you issued the determination letter, did you believe it was appealable?
Yes.
And you were working with Mr. Hediger at the time, and what was his capacity?
He's my boss.
And would he be a code enforcement official?
I'd have to check with the, honestly, I wasn't sure.
Did you consider him to be the highest authority in your department?
He was a director.
And so all the code enforcement officers worked for Mr. Hediger?
He was a director, yes.
So wouldn't it seem a little strange that you could appeal the determination of a code enforcement officer, but you couldn't appeal the decision of the officer's boss?
Objection, this is going beyond his personal knowledge and asking to know what a prior counsel was thinking.
Can you answer the question?
Can you repeat the question, please?
Yes. So you're saying that unless you're a code enforcement officer, you can't appeal to the Board of Appeals. Is that what you're saying?
That's not what he said.
I'm
Well, you said-
trying to understand the question.
Testifies that you believe your determination was appealable.
Yeah, at the time,
And you did not know, you did not waiver from that until you talked to your attorney. Is that correct?
Objection, attorney-client conversations are not relevant.
It's
They're
in the
not-
record.
They're not part of.
It's well within the record. It's within our FOIA request. I think it says right here. David and I then spoke with Mike, who had the opinion that as I am not a code enforcement official, technically my letter cannot be appealed unless it's adopted by Nick, Steve, or another CEO. It's been waived.
And the record speaks for itself.
Sorry, Attorney Curry, I didn't hear that last comment.
Then the record speaks for itself.
Thank you.
So this was something that your attorney came up with, not something that Mr. Hediger came up with.
Objection.
Duly noted. Now, Mr. Tebow, do you recall when you first met me?
yes.
And what was the purpose of that meeting?
It was about 36 Shore Road. You were asking, you were pointing to that specific language about,
AC1D?
I defer to you.
Well, no, the question's to you, sir.
Well,
Do you
I'd have
recall
to-
why I reached out to you?
yeah, but you referenced an ordinance of which I would have to double check specifically what you're referring to.
And I was also referencing an opinion that you had issued to the sellers,
An email, I think?
an email. And in that email, you and Mr. Hediger had basically told the sellers they couldn't do anything with this property. Is that roughly correct?
In the email.
Objection, mischaracterizes the email.
Well, what was the purpose of the email to the preventures?
The email from last May, I'd have to double check what that email read.
You don't remember?
It was a year ago.
You have no recollection?
I remember it was about.
Yeah,
Mr. Bond, is there an email that I have that's
Yeah,
representative of?
Mr. Chair, it's Exhibit 4 to the city's memo from Friday. And while everyone's looking for that, staff will stipulate that a former Director Hediger was a code enforcement official. He was certified by the state in these areas that are at question.
And before you sent out the determination letter, Mr. Tebow, you passed it by Mr. Hediger, is that correct? Is that an email that you?
Hold on a second. Do you have enough copy?
My question, sir, is that email one that you received from Mr. Hediger before sending out the determination letter to me?
I would have to see the email that I sent to you to know the time. It's possible.
Did you have another question, Mr. Bond? I'm sorry.
Mr. Tebow asked me for an email. Do you recognize that? Speak up so the record gets.
Yep.
Yes, I do recognize this.
And can you tell the board what that is?
It's an email that I sent to you.
With the attachment of what?
Sorry, I don't see an attachment.
That, wasn't that the transmittal email for the December 1 determination?
That was, it was an email that I sent to you, and I'm not trying to be difficult, but I can't. Where does it indicate that there was an attachment?
It says, hi Chris, I apologize, you can read along with me and make sure I read it correctly. I apologize for the delay. Thank you for your patience. We did a thorough review of our shoreline zoning ordinance, but unfortunately, we're not able to find a simple option to develop the property. I wish I could provide better news. Take a look through everything and feel free to reach out with any questions. And that was the transmittal email for the December 1 determination letter.
Objection, that's your statement, not a question.
Do you believe that was the transmittal
Do we
email?
have this one
Determination
somewhere?
letter, December 1, Mr. Tebow?
Yeah, I think so.
And is it copied to Mr. Hediger?
You CC'd?
And he's a code enforcement official.
As far as I'm aware.
And here in this email dated the same date, December 1, 2023, he's congratulating you on the determination letter.
I'm not sure.
Well, let's read into the record. Oi, this is a challenge. Good job documenting the path. Does that sound congratulating to you?
What is that exhibit?
Memo, so we can get our copy.
This is not in the memo, Mr. Chairman. This is, I'll pass it to you. And
I'll hand it right back. Okay, let's add this as an exhibit. Again, for the board, it's an email from Mr. Hediger to Mr. Tebow regarding the subject, saying, "Oi, this is a challenge. Good job documenting the path. Be sure to enter gov possible with a land use hold to." That is the one sentence email that is there.
Mark that as H1 for hearing.
the other emails I was referencing are in.
I have, we have that full package. It's just this one was not there.
And may I have,
Do you, I
yeah,
mean,
that other email back?
don't see.
Sorry, where was the other email?
I don't know what happened to it. Oh. I Unfortunately, I wrote on this, Mr. Chairman, but that is the other email that we.
Objection.
Record.
Objection. You can't put in things into the record without having, I mean, you're writing on them, that's,
I accidentally.
I appreciate it's an accident, but you need to have a clean copy.
Mr. Tebow,
Mr. Bond, let's work our way to whatever other
Yeah.
final questions you have.
so did you do a review of the, before you issued the determination letter on December 1, did you do a review of other structures in the shoreline zone to see if the rule that you're applying to my client was also being equally applied to other people, other properties?
I don't remember, to be honest.
So did this rule come from you, or did it come from Mr. Hediger?
Objection. This rule?
The rule that created a presumption that my client's property was unlawfully non-conforming until we proved otherwise using a building permit.
Objection, that's not what he's testified to.
What was the rule that you testified to, Mr. Tebow?
You keep saying rule. Can you specify the ordinance that we're referring to, or is there?
I'm talking about your December 1 determination letter, which you said that we would need to prove that 36 Shore Road structure was lawfully non-conforming. Is that not correct?
Chris, if you're referring to the letter, why don't you point to a specific point and ask him about specific language? Attorney Bond, excuse me.
Mr. Bond, I know you have a couple more questions, and we'll finish up, but then we have two items that this board will either need to make a determination on, and then if we make one decision, we go one way, and one's to go, we go the other, so.
But, sorry, what specifically? Can you be a little more specific?
The last sentence says, however, because there is no permit on file with the department, it is not possible to determine that the structure was in lawful existence at the time this ordinance and subsequent amendments took effect. The definition of non-conforming structure can be found in Article 12, Section 2.4, Shoreline Zoning Ordinance. And you go on, if the applicant or property owner can provide a building permit granted for the structure, we can determine the date of construction whether the structure is legally non-conforming. This building permit shall indicate the underlying use of the property. Staff can then work with the applicant moving forward with their project. Now, did you know at that time that there were no shoreline, original structures in the shoreline zone that had original building permits?
Objection.
You can answer.
It's based upon your testimony. You can ask him whether he's gone through all of the documents and reach that conclusion for himself.
Did you go through any property records to see whether or not that rule, that property owners would have to bear the burden of proving that their property is legally non-conforming before they could move ahead and even apply for a building permit?
Objection, Attorney Bond. You're characterizing, you're reading this as the rule, and you've not asked him whether he sees it as a rule or what he meant when he wrote that. You're characterizing it improperly.
Mr. Bond, I'm going to bring it back, so come on back. Do you have any additional questions at this point for Mr. Tebow or for Attorney Carey or for any other members of the City of Lewiston staff at this time?
Mr. Chairman, I feel like these questions are being evaded. And I just need to make a blank objection. I put the document right in front of him that he is the author of, and he refuses to answer questions about it. So I'll just state that for the record and let it go.
Your comments have been stated, they are on record, they are on the recording and so forth, and we've heard your comments related to them. Does anybody from the board, we've closed the public portion of the hearing, does anyone else have a question for staff or for Mr. Bond or the applicant? Okay, hearing none, we are bringing back to the board for consideration. First item at hand is we have conducted a hearing related to the December 28, 2023 petition. We've obtained input from both the applicant as well as the city staff. I need a motion from the board that the application is complete. Motion that the application has been complete.
Like a motion.
Motion from Mr. Agron.
Yes.
Do I have a second to the application being
I'll
complete?
second.
Second from Paula. Sorry. So the application is complete. I am going to be looking for someone to make a motion that pursuant to Appendix A, Article 8, Section 4A of the Code of Ordinances of the City of Lewiston, the board either does or does not have jurisdiction to consider this petition. Looking for a motion, one way or the, I need a motion from one way or the other. Does or does not? Staff, we'll come back to this, to staff. Staff has recommended that the board does not have jurisdiction to consider the petition for the two reasons. First, Planner Tebow is not a code enforcement official, and that the December 1st, 2023 memorandum is not a decision, determination, or interpretation. That was asked of the staff in through questions. Mr. Bond has many questions as well. I'm looking for a motion, one way or the other. Yes,
I'll
Paul?
make a motion that, no, we are not, we do not have jurisdiction over this. One, Planner Tebow was not a code enforcer at the time. So we can make a record of that, Shelley, as stated on here.
So we have a motion from Paula that the board has not have jurisdiction due to the fact that Planner Tebow is not a code enforcement official, and this was memo of December 23rd is not a decision or determination or interpretation. We have a motion. Do I have a second for the motion?
Second.
Seconded by Melanie. With no further questions, Shelley, can I have a roll call vote? Roll call vote means in support of the motion is a yay.
Okay.
Okay?
Yep.
I'm making sure everybody understands a yay via name, so.
And just for clarification, is that both motions? Because you had a motion that was complete, and then this motion.
We had already done the motion that was complete, that was voted upon, and.
I'm sorry, I didn't hear the roll
Yep,
call.
sorry,
for
that was
Okay.
voted on, that the application was complete.
One
need to know-
point of order, we need to know which member is standing in for Mr. Dubé.
That was Mr. Agron.
Mr. Agron,
Yeah.
okay.
I'm sorry.
And I second that.
Yes. So, roll call vote, again, a yay, is that the board has found that the petition, that the board does not have jurisdiction. That is a yay, okay, if that were to be just clarification. Shelley,
Okay. Jeffrey Goslin?
I'm a yay.
Daniel is not here, so Paula Maselli?
Yay.
Bernard McAllister?
Yay.
Melanie Dorn?
Yay.
David Projansky? Paul Colasante?
Yay.
And Matthew Agron.
Nay.
So we have a vote of 6-1 in favor, that the application, that the board has found that does not have jurisdiction to consider this matter. That being said, the rest of the items to be considered are null and void at the present time. So we have no other items on the agenda other than the reading of the minutes. We have minutes from August 30, October 18th, February 21st. We have several people who are not here for many of those meetings, but we still have to address that these meetings are, so, Paula, has everybody had a chance to review the minutes?
I have, and I was at all of them.
Can I have a motion to accept all three sets of minutes?
I'll
Paula?
make a motion to
We have
accept.
a motion by
Okay.
Paula for all three sets of minutes. Can I have a second for the acceptance of minutes?
I would second the motion on the February 21st where I was here, not sure that I should be making motions on things that I'm not here for.
The only one who might be here might have been
I
Matthew or
second- I
Melanie.
second.
Might have been Melanie. All right, so you second, so Melanie seconds, so we have a second from Melanie. Anyone, or actually, usually that's when we're on Zoom. All in favor of the minute, of the acceptance of the minutes? You have a 7-0. That being said, is there any other business for the City of Lewiston's Board of Appeals meeting this evening? Shelley?
No.
Anything on the agenda that we're going to be seeing in the next few weeks?
We don't have any active applications at this time.
Thank you very much. Hearing none, do I have a motion to adjourn?
Motion.
Moved by David, seconded by Paula. We're done.
Thank you.
Thank you, Mr. Bond. Like I said, it's worked out.
It's nice working with everyone.
Well, that's
Not a regular.
the